Hey everybody, good morning. I'm JD Houvener and welcome to the Bold Today Show. I'm here every Wednesday, 9 o'clock on the West Coast and noon on the East Coast, talking about patent law and intellectual property, trademarks, copyright, trade secrets, bringing on all the live questions that you guys have. I would love to have those live discussions. So if you are on or plan to be on in the next couple of minutes, I will be prioritizing your questions. So look forward to those. I've got 5 avo.com questions I'll be going through later on today. So they're kind of been preloaded. So if we don't have any live questions, I'll be going to those. I am the owner here at Bold Patents Law Firm. And we have a network of 6 or 7 patent attorneys, and we help inventors across the country, nationwide, with getting their inventions researched, help them apply for a patent, and then get the patent. And then we're well plugged into different networks to make those referrals to get you in touch with business attorneys, prototypers, marketers, licensing professionals, help you make money with your patent. So we're excited to be here today. And I'm talking about freedom to operate. Freedom to operate is the topic for today. And I'll be speaking with you about 5 to 10 minutes, depending on if there's any questions. And then jumping to our preloaded questions after that. So being an attorney, I want to make sure you guys are clear that by nature of this broadcast, you are not a client and there's no attorney-client privilege during this discussion. But if you want to become a client or interested in seeing if, now is the right time to take action and to protect your invention, I'm going to be providing a link to schedule a free screening session with one of our advisors. And they can help you think through, is it the right time? Have you got, from an idea to an invention, and is now the right time to sit down and sit kneecap to kneecap or video conference with one of our patent attorneys in an actual legal consultation. So I'll be providing you that link in just a little bit. And also, if you want to get hold of me, I'll provide you my information personally. I have a text-only phone number, and of course, you're welcome to send emails to jd@boldip.com. And I'll either answer those right away or bring those to this forum next week to move those forward. All right, I've got 2 live viewers. Good to see you guys, and thanks for the like out there. I appreciate it. We're trying to create a lively environment. For today, the topic is about freedom to operate. Freedom to operate, and some people don't even know that that's related to intellectual property. This sort of thing. What do you mean, freedom to operate? Operate what? And why wouldn't I be free? We're in this beautiful country, United States of America, where there's a whole lot of freedom to be celebrated, to be thankful for. But this whole concept is about, okay, I have got a product or I've got a service and I want to be able to just sell, okay? And am I at risk? How much risk is probably a better question do I have about getting sued by someone else, okay? And it may not happen right away, but what is my risk level? If what we're developing, our app, our new gadget, our kitchen product, our consumer product, if it goes on TV and we sell like hotcakes, who is going to be coming after me? Right? Who's going to be coming after our product, coming after our trademark, our company, from a competitive point of view? And what angles will they have in terms of attacking what we're doing and seeing if we have any weaknesses? What are the liability standpoints? And so I'll be looking at 2 major aspects in how free you might be to operate. One, of course, is patent law. The other is in trademark. So let's take them in turn. And this is a great point of view because a lot of our inventors that come to us and they've got a product they believe to be patentable, they want to get a patent on what they've created, whether it be a new technology, they've researched it, come up with a solution, and they want to bring it to market. But before they do, they wisely get a hold of a patent attorney and they consult with us and they say, I want to see if what I've developed is patent eligible and patentable before I go blindly file the application. And we'll sit down with them. We do that research, look worldwide, put ourselves in the shoes of the examiner and look at all the prior art. Prior art is just any publication, any information that's available to, that would be available to an examiner. And in order to answer the big 3 questions of, is there utility? Is it truly new in the world? And is it a non-obvious version of whatever else has come before or whatever else is known in the field of art? So we answer that question for our inventor clients. And sometimes, it's kind of about 30%, sometimes even more. We say, gosh, you know what, Mr. and Mrs. Inventor, you've got a fantastic idea, and I'm so happy you're passionate about this project, but we can't, as from a legal standpoint, recommend that you move forward. Either there's no chance of you getting a patent, or the chances are so slim, or we'd have to reduce the scope of rights so that your patent would be so narrow, it wouldn't really be worth the the writing on the paper, and you wouldn't be able to get enforceable patent rights over what you're trying to sell. So it's a tough conversation, but it's one that I'm really proud of, that our attorneys are really impassioned, and we feel like it's a very good service to tell that client that tough news. But that's not the end of the line. For a lot of our inventors, they say, okay, well, I can't get a patent on this, but I'm still going to sell it. I still want to go to market. And they ask, well, and they may not be knowing at that time that what they should also be looking at is, okay, well, they can't get a patent, but are there others that have patents on what they're selling that might come after them for what they're selling? And that is, an infringement concern, whether their product might be up against a design patent that's issued. And we can help them with providing a freedom to operate opinion after we do that analysis and say, no, we don't think you can get a patent. Let us take a look and make sure, if you're going to go out to market, what's your risk of being sued by someone else on the patent side. Hi, Vajush Kanti. Nice to see you. Thanks for tuning in from India. I appreciate that. Let me know if you have any questions at all. Be happy to take those up first. All right. Well, so the scenario where we're now analyzing enforceable patents, right? Enforceable patents, usually we just look in the US, but certainly we could provide this opinion worldwide. We'd have to include our other partners in other countries. But traditionally, our clients are interested in, okay, in the US market, who has patents in this space, and can we sell our product without infringing on those patents? And that opinion is looking at the actual products they're going to sell. And for a lot of inventors, it takes a while to educate them on what they were trying to get a patent on, okay, is a small aspect of what they're actually selling. Let's take, I don't know, a forklift, for example, right? And so someone has invented a new structure and system for that actual, the fork part, right? The actual metal, usually it's metal, part that actually will hold the load, right? The load-bearing portion. But there are other aspects to the forklift: the motor, the engine, the seat, the housing, the shield, the whole aspect of the hydraulics and moving it up and down. They're hoping to just use that, some sort of a state-of-the-art, normal, if you will, version of that forklift base. But they've invented a new tine, right? That's what we're looking for: a new tine or a mechanism to actually lift and hold the payload. That's great, and we ended up doing research on that tine and that the fork itself. And we found that there's so much out there that we don't recommend that they file a patent application on that new tine, that new fork. But they still like it, and they want to try to go sell. They've got great inroads with, distribution centers or big manufacturing plants, let's say at Amazon or wherever else that they think they can do business. And so they're asking, okay, well, can we just sell these without a patent? And so we'll take a look at the other than the tine, right? The actual what they hope to build, or how they're going to repurpose those forklifts, that base model of that forklift, aside from the tine, and see, okay, is there any patents covering that base core forklift? And if they're hoping to sell the whole forklift with their tine, even though it's not patented, the question is, can they sell that package, that complete product, to those distribution centers and warehouses? Can they make it and sell it without infringing someone else who might have a patent on that underlying forklift mechanism? So it's kind of turns the question around, and definitely from a different angle. Certainly underlining the fact that you don't have to have a patent to be successful in business, right? I try not to say that too loudly, but it is true. Patents is not for every company, not for every product, and getting solid legal advice up front from a patent attorney, patent law firm like ours, will help you make that decision on, is it really worth investing in a patent, or can I just go to market? And if so, what are the risks in doing so? So we got just a couple more minutes left. I'll talk about this freedom to operate concept. The other aspect, of course, so there's the patent aspect, which I've just discussed. There's the trademark aspect, okay, and branding. And so for the same reason, okay, you can try to form, and you should form, if you're starting a company, a brand, whether it's a word mark or a logo, some way to distinguish yourself from other competitors in the same marketplace. And so you see that for our law firm, we've got our fancy colors, our blue, our pink, and green with the different formatting of the style of letter B and the D. And we also have the word mark, which is the plain English characters BOLD patent. So those are two separate marks. We have the word mark and the design mark, which is the logo you see. For a lot of companies, it's maybe just the word mark, that's all you need, or maybe you just have a logo. However you're portraying yourself in terms of what you're selling on your services or goods to distinguish yourself. Now, before you go to market, it is wise to hire an attorney in the trademark field, which we also offer trademarks at our firm, to do that initial search to say, hey, can I get a registration for this? And the requirements are a little different on the trademark side, but you have to have distinctiveness, and it can't be confusingly similar. It can't be the same as another registered mark in the same classification, they call it, right? So for us, it's legal services. For others, it could be forklift or heavy machinery, heavy equipment machinery. If you've got a new forklift company, and so whatever it is you've come up with for a word mark or a logo for that forklift company, you want to do that research to see if you can get registration for that forklift company. Let's call it heavy lifters, right? Heavy lifters forklifts. And so heavy lifters, after doing research, our trademark attorney breaks the bad news that there's already a company out there called Heavy Movers, and they have a big equipment industry. They've been going for years, and heavy lifters it's not going to be different enough, and it will likely be more confusing in the marketplace. So our attorneys give you that opinion, which in a way puts themselves in the shoes of the trademark examiner and tells you, oh gosh, you've got to pick a new name or find a way to just avoid infringement. And so let's say you go back to the drawing board and come up with a new name, and you want to just start using that, okay? And once you get registration for that new name, you maybe got, Big Loaders, right? Big Loaders is the name you decide to go with. You get the registration for that, and you go to market and you start using colors and start using a certain type of marketing or a approach or slogans that you have in the marketplace. So in terms of what you're selling and how your brand is being seen by customers, you need to do have freedom to operate on the trademark side as well as the patent side to see if there's any other companies out there using the same trade dress as yours. And trade dress is very tricky. It really only means how customers perceive other companies with respect to colors and sounds and smells, and of course overall emotions or the way they feel about the environment when they get there. A very famous case was decided about 10 years ago. Rosetta Stone, if you guys ever heard of Rosetta Stone, it's a language learning program. They have yellow. Yellow is their color. They have their boxes where they have each language that you can learn in it. And a competitor launched a totally separate brand, keeping their name is different. Everything about it's different, except they also use the color yellow for their packaging and selling their CDs at the time. And so because of that color trade dress that Rosetta Stone had over the years and developed, they were able to prove the fact that this other company was infringing on the trademark side, on the trade dress, even though they had a completely different, distinct name. So in this example I told you earlier, the heavy loaders, right? That's a distinctive name. They can likely get it registered, but it's different, way different than the original mark. But they may have used the same color, maybe purple, right? Purple forklifts, and they decided to color their forklifts purple as well. Well, that is an infringement, even though it's not a direct name or word mark infringement. And so over time, you'd need to change that or get a waiver or a license to be able to use that purple forklift. So anyway, that's the freedom to operate concept of making sure you're aware about who rights holders are on the patents and on the trademark side before you go to market, knowing full well what you're getting into, what the risks are of you getting one of those nasty cease and desist letters, apart from trying to acquire your own rights. Okay, when no live questions came in, what I'll do is I'll jump to our trademark questions that came in this week. I have 4. This first one is out of Monte Springs, Florida. All right, here we go. Okay. I have an existing service business, an LLC, Do I register a trademark? My body or skincare line is a separate business too. I'm an LMT and spa owner. The business is a registered LLC. I'm in the process of starting my private label skin and body care line with a different name than the current business. Do I need a trademark or register this product name on SunBiz or USPTO? Okay, so since you've got, you've got a company, it's a service business, and you want to try to separate the actual products. Try not to overcomplicate it, honestly, in terms of forming the actual entities and if the service company, the name rather, if you can, if it's at all related, if the service company is related to spa service, skincare service, beauty, spa, salon, and now you want to just roll out products, right? In addition, you don't need to start a new company. It doesn't sound like, unless there's separate ownership or separate employee structure. If it's all going to be basically you as the owner of both entities, no reason to necessarily complicate it. That's my initial reaction, and so I would advise you to then get that confirmed with a Florida licensed attorney on the business side to give you some advice on formation of the LLC and how that can be properly constructed, and so that each company is owned right by each other, or how they're nested within each other. On the trademark side, which really has nothing to do with the way that the company is formed, and I know this is a very common misconception, but the trademarks are actually totally part. They exist solely for the purpose of educating and informing consumers, so that they are not confused about where goods and services come from. So you can and should have a separate trademark for your spa service aspect, and then separate mark or marks for each product that you have if you're going to be selling skincare products. And those can be owned by that one LLC or owned by whatever LLC you decide on the ownership. And they do not have to have the same name as your company. Again, another very common misconception is people think that they have to get a trademark for the exact name that they've got their LLC name filed for. And that's not true very much. I mean, we know that probably the most famous example is Google, right? The company is Alphabet Incorporated, and their brand, their trademark is Google, okay? So there's no company out there named Google. And so they've used that to distinguish, and that's how customers know of their service, which is a search engine, much like you could have, a skincare line, called Gold Skin, right? Gold Bedazzle, right? Gold Dazzle Skin. And that's your brand name. That's what you would get a trademark registered for. But the LLC name could be, Skin Spa Care Southwest or something like that, LLC. But Skincare Southwest LLC, that doesn't sound that great, and that's not what you want customers to know your business as. And so that's not going to be what's on the trademark registration. So that's what I recommend, is making sure you get state-specific advice in Florida related to how to form and structure your LLCs, but then think of trademarks as totally separate from those in terms of how you're actually approaching and appearing to clients. Thanks for that question. Okay, let's go to our second one here. All right, this one's out of New York, New York. This one looks like a fun one. So can I use Cruella from, I imagine, the 101 Dalmatians movie, I believe it's a Disney movie, her black and white hairstyle in my unique drawing and sell it? I drew an illustration in a form of a portrait. The woman has red eyes. My own design of an outfit, but I drew black and white hair, horizontally inverted colors, first white, then black. But is it still considered a copied character, even if I use only the same hairstyle as Cruella? Cool. So this is actually a copyright question, and a little bit out of my wheelhouse here. But I'll give you my notions from law school and my time working at an art clinic there at the law school. Jumping right to the heart of the legal matter. If this were to get argued in court, the judge and jury would be up against answering the question of, is what you've designed, which is a I think arguably a derivative work, the owner of, say, Disney, that's the argument they would make, is that what you've made is a derivative work. And so copyright owners, generally, when they create a piece of artistic work, in this case, a drawing or a cartoon character, they own, of course, the copyright on and reproduction rights over what they produce, but any similar adaptations, also called a derivative work, where it's recognizable that it's from the original work. So if what you've created, if you think that the general public, I know it's not sort of the great standard, but the general public would recognize that hair style and think right away, think about Cruella. If that's true, then you might have a problem. I know that's very subjective, and it's not kind of the easy black and white, no pun intended, answer you're looking for, but that is kind of the bottom line. Is even though you've changed the eyes, you've changed the clothing, if the hair is so distinctively close, which is, I think, a major aspect of that character that was created by that other artist, there may be a issue there. So flags are being raised, and so I think my recommendation would be to get with a copyright attorney to get a written legal opinion before you decide to market and sell it. That's really the major thrust of the question here, is if you're going to be using it for commerce and selling it, you want to get at least a written opinion from a copyright attorney before you start getting in deep water, so that at least then if you get that cease and desist letter from Disney, whoever owns rights over Cruella's image and likeness, then you can go back to that attorney and say, hey, I need some help. It looks like I got in trouble. And they will be willing to support you in defending any type of litigation. So please follow up with, send me an email. I'll put that up above with any follow-up questions. Oh, sorry, Dana, I missed your question. Dana Muanas. Let me just put your question up here. Hi, JD. Since you said a patent is not always necessary, what qualities of the product should one analyze to determine if a patent is necessary or not? There's two major things to look at, Dana, in terms of whether to proceed with a patent. And I talk about this in a couple different places, but I have the patent success for an invention to be successful, right? Makes money. You have to have patentability, which is, hey, how new is it? And you have to have marketability. How marketable is it? How much demand is there? How big of a pool is there? How many competitors, and what sort of barriers to entry are there going to be in order for you to be able to sell and monetize that invention? You could have the most unique, groundbreaking invention ever, but because no one knows about it, and honestly, no one cares about it right now, there's no market for it. And so no one's ready to buy it. And therefore, you won't have monetary success, which in almost every case, that's the measure, right? Don't get a patent if you're not trying to make money. So if making money is the game, that's really what it's about. And so you have to make, as the inventor, entrepreneur, business owner, you have to make a decision on is there enough of a market for what you're developing, and then relying on patent attorneys like us to tell you how patentable is it. So that is definitely the first question. If you kind of think there's a big enough market for it, that's why we get approached by most clients. They've already kind of done some of that groundwork and convinced themselves that, yeah, this is a big enough of a deal. It's a cool solution. I could see this being, something that others that have the same problem could also put into place. And so they come to us already kind of having that notion that there's a big enough market demand. And they come to us to say, hey, is this patentable? Could I get a patent on it and be the only one allowed to make, use, and sell this invention for up to 20 years? So that does sort of answer that question. The second question, which I don't know if you asked directly, but I'll give you the answer. We do advise clients on whether to seek a patent or whether to keep that information as trade secret. And the big key term there is whether it's reverse engineerable. So let's go back to the forklift example. If you were staying with me, if that tine, right, that tine that we're making, if you've invented not actually the different structure, but let's say you've invented a new type of metal, that's stronger, more durable, and with all the right heat treatments and combination of at the atomic level, you've actually got it to be stronger than the state-of-the-art tine for lifting. And so you can actually make it smaller and it's just as strong. Well, the question is, okay, if you were to sell that tine on the market your competitors, right? Could they actually break apart your tine, or, through, means of breaking it and chemically analyze to see how you built that? And if they could figure out what kind of materials you put into that tine and make it themselves, okay, you want to get a patent on that tine, on that material that you've created. But if they couldn't, right, they can't take apart that tine, there's no way they could backtrack and find out how you did the heat treats or how you formed it and applied all these different processes to get to that end product. You should actually keep that as a trade secret and just continue selling those tines, and your competitors would remain stumped as to how you're actually making that. And the beauty there is that you can sell that for much more than 20 years. I mean, look at the wonderful reign that Coca-Cola or some of these recipes out there. Airplane manufacturers have been making wings and parts and materials well beyond the 20 years that you get by a patent. And you can keep it as a trade secret instead of publishing it and sort of sharing that knowledge. You can have a competitive advantage for much longer. So reverse engineerability is huge. Success in terms of monetization is really the big question on whether you should file and get a patent. Hope that helps you, Dana. Just a couple more questions left, a couple more minutes left. We'll probably wrap up here. What I want to do is provide a link for any of you who are kind of on the fence, not sure whether your invention is ready for patenting or not. I want to provide you a link to schedule. And this is a free consultation. It's a free meeting with one of our advisors, and they'll hear about what you're up to. And if after talking with you, it's a good fit for our firm, what we'll do is we'll recommend that you talk with a patent attorney on our team for a paid consult. But at least taking a first step and learning about what we're up to, what our firm is like, learning about who the attorneys on our team are, answering anything. Yeah, you're welcome, Dana. Absolutely. So there's that link. Click that and schedule some time, get on the calendar. And for taking action, I'll give you a copy of this book, right? I mean, the Bold Ideas, Inventor's Guide to Patents book. It's got all the basics from what a patent is, the difference between patent and trademark, copyright and trade secret. And it gets into some of this freedom to operate stuff I was talking about today. So awesome. Well, thank you guys for joining. I appreciate those live questions. Keep those coming in. Hope to see you guys next week. I'll be here every Wednesday, 9 a.m. Pacific and noon on the East Coast. Take care, everybody. Go big, go bold.